bolts of an HOA, because it's all about a lot of things, but mostly about covenants. And as you all know, that is so important for you to really know everything you possibly can about the legalities of monitoring and how to change your covenants. So again, my name is Georgie Rasco. I am the Executive Director of Neighborhood Alliance, and I have with me Ana Herrera, the Southside Community Organizer for Neighborhood Alliance, and Sarah Lawhead, who is the Northside Community Organizer for Neighborhood Alliance as well. And we couldn't do anything without them. So thank you for both of them for helping us. Neighborhood Alliance, okay, if you could go to the next slide. Neighborhood Alliance is, again, a 45-year-old nonprofit organization. We won't go through all of it. We'll go through these very quickly, Sarah. We work with over 600 different neighborhood associations. We have a contract with the city of Norman, as well as the city of Oklahoma City, the Oklahoma City Police Department, and we work trying to help create safe, beautiful, and healthy neighborhoods for all. We work with voluntary and mandatory associations, so don't hesitate to give us a call when you need help. Okay, Sarah? We do a lot of workshops throughout the year. You can go on our homepage of our website and sign up for our email list, and that way you will know what workshops are coming up, figure out which ones sort of suit you and your needs in your neighborhood. Let your other board members know, let your membership know, and they can attend whatever workshops they feel like fit them as well. So again, we would appreciate if you would donate for tonight's workshop. Typically there is a charge for this workshop. Like I said before, Matthew has donated his time for this, but these workshops are part of what helps us to support the organization and keep our doors open and our staff readily available to help you when you need it. So we will make sure that you get information on how you can donate to Neighborhood Alliance, you individually and or your neighborhood. So thank you very much for that. I introduced you Tuesday night to Matthew Winton, who is our speaker. You got to hear from him that night, and you're going to hear much more from him tonight as well. So look forward to that. Get your notebooks ready. You will also tomorrow or the first of next week, you will be getting a copy of both Tuesday night's and tonight's slides. So you'll have those for reference as well. I also on Tuesday night introduced you to our sponsor for these workshops, and that's Michael Bittinger. He from the Michael Bittinger Real Estate Company, and he is here in person tonight. He just flew in from his ski trip, which he wasn't able to be here. That's why he wasn't able to be here on Tuesday night. So I'm going to turn it over now to Michael and let him introduce himself to you.
Georgie, thank you very much. It's always a pleasure to be here. I love to talk about real estate, and I love to talk about property management. And we're in that business and have been in that business since 1988, formally here in Oklahoma City. And we do a substantial amount of homeowners associations. Right now, my slide presentation said we have 8, but we actually have 9. We've signed on a new client. And I just wanted to tell, I know that you've seen everything that is on our screens. And Sarah, you could move it to the next screen if you want to. And this shows when we were formed and my work experience in it. And you can go to the next one, Sarah. And then, as you can see, we have 8 associations that we will with, but it's actually up to 9. And the one thing that I wanted to, this screen also tells you about the types of associations. So there's various homeowners associations, as you're all aware of. I mean, they could be condominium associations, they could be townhome associations, they could be platted additions, many different things with Matthew's been talking about with you. And so that we do and that we work on. And I just wanted to make sure, because a lot of people think that a property management company is going to come into your organization and tell you what to do. And that's not the case. When we go to work for a homeowners association, We work for that board of directors and those homeowners, and we do what they want us to do. And we give guidance. And if it's issues with covenants, conditions, and restrictions, rules and the regulations and bylaws, we might refer that, if we don't have enough experience in it, to Matthew to let him help you with those things. And also, but we can help you with other property issues, such as how gates works or repairs, swimming pools, clubhouses, streets, all the different things that you need to know. So just wanted to say that to you. Thank you very much. I want you to have a wonderful night tonight. I'm going to look forward to hearing our next speaker.
Thank you, Matthew. Michael, too many M's here tonight. Thank you so much for sponsoring these workshops and for the wonderful work that you do in management as well. Yes, our next speaker for tonight, before we get to Matthew, we're going to hear from Valencia Doolin. She is the Home Ownership Director for the Home Housing Finance Agency here in Oklahoma. And she is going to talk about the Oklahoma Homeowner Assistance Fund and how that can help you and your homeowners both. She's got a win-win proposition for all of you. So Valencia.
Georgie, thank you so much. Thank you guys for having me. I want to introduce you to the Oklahoma Homeowner Assistance Fund. The Oklahoma Homeowner Assistance Fund is made available through the American Rescue Plan Act. You might be familiar with some of the things that they've done in providing financial assistance to Oklahomans that had negative impact because of COVID. Well, this is the first time that there's been money made available to assist homeowners specifically. So this money has been made available and is administered through the Oklahoma Housing Finance Agency to help homeowners who've experienced a significant financial hardship due to COVID-19. One of the eligible expenses, which I'm sure your folk on the line tonight will be glad to hear, are Delinquent Homeowners Association dues. And so if you have homeowners within your neighborhood associations that have Delinquent Homeowners Association dues and they have had a significant financial hardship because of COVID, meaning that they have been delinquent since January 21st, 2020, we actually have the ability to help them to catch those dues up. It is a very simple application process. They apply online. I have provided the email address and the web address for you in the chat, but the Neighborhood Alliance is going to be sending out to you a hard copy flyer that gives you all of the information about the program in the coming weeks. The best part about our program that I want to make sure that I mention to you before I let you go on with the rest of your evening is that we believe in the honor system in Oklahoma. And so our program is based on self-attestation. That means that people are not going to have to provide us any great lengthy documents to prove that they've had a financial hardship since COVID. We know that many of our Oklahoma neighbors have suffered, and essentially in the application, all they have to do is tell us that that is the case and attest that they are telling the truth, and we believe them. And then we will be contacting them to find out how delinquent they are, what amount needs to be paid, who that amount needs to be paid to, and processing the applications to approve as many people as we can. I will tell you that each Oklahoma household that is deemed eligible and can be approved has the opportunity to receive a maximum of $20,000 in assistance. It is a grant and it will be paid directly to the vendor. So in your case, it would be paid directly to the homeowner association and not to the homeowner themselves. I hope that you all will find this information useful, and we hope that you will use it, find a way to share it with all of the neighbors who live in your neighborhoods. And please do go to the website for more information about how they can apply.
Excellent, Valencia. This is great information, and it's really going to help. Like I said before, not only homeowners to get that burden off of their back, but the HOAs that are desperately in need of being able to fill their coffers again from back dues that they haven't been able to collect. So thank you so much for coming on and telling us the information.
Absolutely. I look forward to hearing from you guys.
Thank you. All right, so we're gonna turn it back over to our friend. All of you as of Tuesday night can also now call him your friend as well. Matthew Winton, who is going to take us again this evening on a journey on learning more about how to run an effective and legal homeowners association. So thank you, Matthew. It's all yours.
Okay, well, thanks. Thank you, everyone, for joining us again. Ms. Doolin, thank you for joining us. That's fantastic information. And I think each of us will do our best to let our the various contacts know that program is available. That's amazing and incredible and very timely and needed. So I'm glad you could join us tonight. So I'm going to share my screen. We're going to hop back into the seminar. If I can find it here. There we are. Okay, so kind of the same format that we did last week. I'll run through the slides. I'm not going to read them to you. I've got the stuff I want to talk about. You've got the questions you want to talk about. So put those in the chat and we will cover those. So same disclaimer as last time. We'll skip that. Same HOA condo resources as last time. I'll skip that. And just a very quick review from last week. The law, if you're wanting to know where the law is, this is a brief overview of the condo, the REDA, Real Estate Development Act, or the HOA Act, and the Oklahoma Corporation Code. And then you can find all of that at oscn.net. All right. So for part 2 of our time together, we're going to take a little more time going through the specifics of assessments. Then we're going to talk about collections of assessments, including small claims collections cases, district court collections cases, liens, bankruptcy, foreclosure, and then we will move into judicial enforcement. There's always a lot of questions. And I'll go ahead and tell you, not necessarily as a downer or a spoiler alert, but when it comes to talking about litigation, like I said last time, no lawyer can tell you that you're going to win. No lawyer can tell you you're going to get all your money back. And it's very difficult to make predictions on some of these cases. I definitely can't make any predictions based on just hearing a question. Any kind of opinion has to be reasoned, has to be based on an understanding of the facts of a particular case. So we'll talk in generalities. I know one question came in about associations waiving covenants. We'll cover that in just a little bit. Then we're going to move into talking about amending covenants. So if the covenants don't do what we want them to do or need them to do, or if they have language in them that prevents us from doing what we want to do, then there is a mechanism for amending them. We'll talk about that. And then as time allows, we'll spend time talking about association insurance, the various kinds of insurance that associations typically will place. And then we'll talk about some board function do's and don'ts. All right, so let's talk about assessments. If, going back to the prior slide, if we were to look in the law in Oklahoma, the Condo Act and the HOA, the REDA Act, you're not going to find this breakdown of assessments, okay? What you're going to find is, in fact, you're not even going to find a simple breakdown between regular and special assessments. Nothing in the law in Oklahoma about that. Maybe we will someday, but we don't now. So this terminology, this breakdown into categories, is something that we have just made up. When I say we, someone long before me, lawyers, real estate professionals decided, look, we need to take the association financial pie and we need to slice it up a little bit. So that's what we're talking about with annual, special, specific or individual assessments, and then reserve assessments. Okay, on this slide, I do want you to see that I have a reference to CAIRF BPR for reserves. Now, what that means is Community Associations Institute Research Foundation. In fact, I will put that in the chat here. Community Association Institute Research Foundation, and then BPR equals best practices reports. So CAIRF, you can go to, if you Google that, you'll find them, cairf.org, and you will find in their publications section some free PDFs on various association topics. One of them is on reserves. It's really good for community association boards to be familiar with what reserves are, because Oklahoma law does not require you to have a reserve. If you're a condominium, whether your covenants, bylaws say you have to have one, consider it a mandatory thing. You have to have one, even though our Condo Act doesn't require it. If you're a homeowners association, you've got a detention pond. If you're a homeowners association and you have a private road, you should think very strongly about having a reserve fund. So we would look and find in the covenants the different categories, the different requirements for assessments for our particular neighborhood. Again, just like I mentioned last week, I don't want you to take something that you hear tonight and go away from here and say, oh, well, we need a reserve fund. The lawyer said it, and so now we're going to start charging people reserve fund dues. You're not, unless your governing documents provide for it. Okay. And again, if they don't provide for it and you want them to, well, then you can amend them to adopt the kind of assessments that you need or want. I saw a question come in. Are there any rules about keeping money in an interest-bearing account? None. Occasionally we will come across language in covenants or bylaws that require the association to keep its reserve monies or special assessment monies in an account separate from general operating or regular assessments. That's not real common, and a lot of associations are going to do that anyway. But there's nothing in the Condo Act or the RETA that requires you to put it in an interest-bearing account, or prohibits you, or requires you to keep them in separate accounts. So what are these? What are the different types of assessments? Annual assessments, pretty straightforward. And whether it's called regular, annual, monthly, base, whatever the descriptive term is, what these are, the regular occurring assessments, usually on an annual basis, sometimes on a monthly basis if it's a condominium. And these may be able to be increased by the board. Last Tuesday, I referenced the covenant set that I use. I have a standard form that I use on projects. That form, the default is the board can increase regular assessments 20% per year. Now, very rarely is a board going to actually do that. If we're having a 20% swing, we're either in the middle of a pandemic and prices are going through the roof, or we haven't been paying attention to our budget for many years and we're trying to catch up. So it would be unusual for a board to increase 20% in 1 year, and certainly over multiple years. But if we need it, we want it. Otherwise, if we want to increase beyond whatever the covenant provides for, then you can always amend or adopt with a majority of the owners if that's what the covenants provide. Special assessments. Now, almost always special assessments refer to a non-regular, meaning it's periodic, it's episodic, it's situation based. You know, we have an unexpected budget item pop up and we need to create some cash quickly. That's usually what special assessment means. Now, I do have one condominium client in Tulsa. Their covenants talk about special assessment, and it is this normal idea of special assessment that it's something that we weren't expecting and we need to raise this money. But then it also has a paragraph and it calls special assessments what we normally call specific or individual assessments. Specific individual assessments are basically monetary penalties, fines, okay? This would be another slice of the association's financial picture that oftentimes the association would rather adopt a monetary penalty to address an issue as opposed to filing a lawsuit and seeking an injunction. So we'll talk about specific assessments in the enforcement section in just a little bit, but specific assessments are a very cost-effective way to enforce covenants. And again, it's one of those things, if you don't have it in your covenants, you don't have it. Your board doesn't get to make it up. Your board doesn't get to take the easy route and adopt bylaws. Because like we mentioned last Tuesday, boards under Title 18, Section 1013 can unilaterally amend your bylaws in a homeowners association. It's questionable whether they could do that in a condo association because we have a specific statute dealing with that in the Condo Act. But when it comes to enforcing monetary penalties, we treat those like assessments. Definitely, if you want to file a lien based on specific assessments, that has to be in your covenants. All right. And then we talked a little bit about reserves. Reserves, it's not the money that the association has left over at the end of the year. A reserve is a funding plan for anticipating the pool needing to be resurfaced, or the detention pond needing to be dredged, or replacing gates which routinely go out. High ticket cost items that we can't necessarily absorb with our normal operating budget, then we're going to reserve. And reserves are usually done according to a plan. All right. Now, getting away from some of the language on the slide and just talking to you about what we find in our practice with accounting and the way some associations are doing business, and how to maybe streamline the process, provide a little more customer service to the members. Maybe the first step is thinking in terms of the members being provided customer service by the association. The purpose of the association, I don't know if I said this last week, it is not to take money from the members and to tell them what they can and can't do. Those are not the primary purposes of any association, whether it's a condo or a homeowners association. The primary purpose of your association is to promote community. And the board's primary task is to figure out, how do we promote community with the money that we have, which is always woefully inadequate. So the board is tasked with figuring out, how do we promote community? The idea of giving customer service, offering customer service is, in my mind, part and parcel with that primary mission. Now, in order to effectuate or to pursue that mission, the association needs money, just like any other entity, just like any other organism that it needs energy or some kind of thing to fuel it. Your association discharges its obligations by collecting assessments. So having a system, making that as easy as possible on your members, that's providing one means to provide good customer service. So electronic payment, whether it's an ACH, whether it's an online payment portal, whether it's accepting PayPal, whatever it is for your neighborhood, then that's a good idea. I still have some associations that they will bring us a collections file, and it is actually on ledger paper. It's in hard copy and it's in ledger paper. There's not anything necessarily wrong with that, except that it's so easy to carry a one when we shouldn't, to miss a column. Who knows whether a judge will look at that and think, if they're using ledger paper, there's got to be something wrong in there. I could see that, or us drawing closer scrutiny if that's what we're using. So there are all kinds of accounting systems out there, even down to an Excel spreadsheet or Google Sheets. So encourage you to use some of those and streamline the accounting system. Makes it easier to provide owner statements. It definitely, on the collection side, it makes our job a lot easier in order to check the collections, check the accounting. We talked about this last week, and as we're going to start moving into some collections issues, some of the things that we're going to scrutinize and that we're going to look at when the collections case comes to our office, and we're going to do the same things that we and your members expect the board to do, and that's you get the correct amount, you get the amount right. You're not charging more than what the individual actually owes. You're charging the correct penalty interest or interest rate. So where this comes up is if your covenants provide for 10% penalty interest and your bylaws provide for 18%, we have to use the 10%. And again, this goes back to it's a fundamental real estate principle that if something is recorded in the real property records, that gives constructive notice. Bylaws don't give constructive notice because they're typically not recorded, again, unless it's a condominium association. If there's a conflict between what's recorded in the real property records and what's out there in the corporate records, most of the time, and if we're talking about late fees and penalty interest, we are talking about that time, the court's going to apply what's found in the covenants. Again, whether it's monetary penalties, penalty interest, those kinds of things, got to have that in the covenants. All right. So can't tack on $25 late fee just because we want to. Okay. So I come across this occasionally with liens, and whether it's an HOA manager, a third party, an attorney, agents do not have the right to sign and file liens on HOA members unless they've been given a limited power of attorney. An engagement agreement with me, management agreement with a manager, those are not powers of attorney. There has to be a limited power of attorney executed and filed with the lien so that people looking at the real property records know as a matter of law that that person has been given the authority to sign on behalf of the corporation. If you think about this, we know this. I could hire a realtor to help me sell my property, but that realtor does not have the authority to go to closing and sign my deed for me unless I've given him or her the authority to do that. Spouses don't have the ability to sign on behalf of their spouse to sell away their interest in property unless they've been given a power of attorney. So just something to watch out for. We can check for these things on the front end so that we don't get surprised in court. We don't have a member who is in collections raise this. Another thing, and it doesn't really make a difference from a legal standpoint, but I have had small claims judges deny an HOA a judgment in small claims court because the association couldn't show that they had a consistent means of giving notice of the annual assessment. So having a piece of paper or having a electronic, the ability to print off an electronic copy of an invoice to that individual, I have had small claims judges deny judgment. So having the ability to track invoices, not just simply relying on the argument, well, everybody knows that we pay $120 a year in dues, the covenants say it, so we don't send out any notice of it. You're taking a risk there. So, all right, saw a couple of comments come in. Let me look at that. Question about payment of back dues after a tax sale. Can't speak to what you were told, but I can tell you that whether it's a regular foreclosure or a tax sale, once that sheriff's deed or tax deed is issued, that debt against the property is gone. Now, maybe the association could go after the prior property owner, but the new property owner is not personally responsible, and the function of the tax sale and the foreclosure, the sheriff's sale and foreclosure, is to wipe all of that debt clean. So if you have someone telling you that there are dues or liens owed on property after a completed sheriff or tax sale, you might suggest they get better advice or better information. So comment came in, manager as opposed to board. I'm assuming the question is in reference to me talking about who can sign the lien. Board is the individuals, the entity who can sign on behalf of the entity. So board members, officers of the HOA, they can sign. You can have an agent sign for the entity, the corporate entity of the association. You just have to, the board has to give that agent the legal authority, and the way you do that is with the limited power of attorney that gets filed with the lien. Question about statute of limitations. We're going to talk about that in just a little bit. One of the questions about going after a mortgage company for late dues, we'll talk about that in a second as well. All right, so let's talk about some of the nuts and bolts of assessment liens. All right, I talked about who can sign, don't have to talk about that. One of the things that we hear about HOA liens is that, well, you have to, we hear two things, and they're both incorrect. One is that you have to sue or file to foreclose within 1 year, otherwise it goes away. That is not true. The second bullet says not MMLs. That MML is short for mechanics, materialmen, and laborers liens. MMLs are the type of lien that if I have a roofer come out, they put a new roof on, and then I try to stiff them on the bill, they have the right under statute under certain circumstances to file a lien against my property. That is a different kind of lien than a homeowners or a condo lien. It's governed by an entirely different set of statutes in Oklahoma. And condo and HOA liens do not expire after a year. All right. So that's one false thing that we hear about liens. Another false thing we hear about liens is you file it and you can sit on it forever. And when the person sells their property, they have to pay you. That is not correct either. A lien is only evidence of a debt. Okay. It tells the world that, hey, there's something about this piece of property that there's an amount tied to this piece of property, and it's secured by this lien. it doesn't mean that lien lasts forever, because there is a statute of limitations on collections. This is one of the questions in the chats. The statute of limitations for collecting HOA debt, and this is going to be infuriating, is either 3 years or 5 years. Okay, it's maybe 3 years because these debts, these assessments, are in the nature of an oral contract. Okay, it would be 5 years if we consider them based on written contracts. Now, there is plenty of case law that says covenants are in the nature of a contract, and of course they're in writing, they're recorded with the real property in the real property records. There's no question about that, and that's where we get the 5 year from. We get the 3 year maybe because there's an invoice that goes out. It's not really a written contract that the buyer enters into with the association. It's kind of an imposed contract that it comes with your house. So we have one court case where the Court of Civil Appeals acknowledges that the statute of limitations is either 3 or 5 years, and then they don't answer the question. They said, well, it's not in front of us, so we're not going to answer it. So you could take the better safe than sorry and bring an action within the 3 years, so there's no question you're within a safe statute limit, or you can wait for 5 years. But a 10-year lien, in other words, a lien that's been on file for 10 years, you can only collect going back at most 5 years of the debt. All right. So having a lien on file, it does help, and it is a incredible enforcement tool that condo and homeowner associations have in Oklahoma that general creditors don't have. But they don't last forever. Okay. Something that is important to understand as well, and sometimes we hear this from debtors, is, well, I'm not going to pay my dues. The association can file a lien. I'm not selling my property anytime soon. There's nothing you can do about it. Absolutely false. What the association can do about it, just like your mortgage company can do if you don't pay your mortgage, is foreclose on that lien. And so in Oklahoma, if you don't pay your HOA or condo dues, you could lose that residence, your home, your homestead. Homestead protection doesn't affect selling an HOA lien or a condo lien, just like doesn't protect you if you don't pay your mortgage. So very effective remedy, has to be used right, has to be executed right, and does not have to be filed year after year. This fourth bullet down, this continuing lien language, it doesn't make sense to file lien year after year. In fact, lien is out of date the moment you file it. If the debtor if the debtor owes the association $200 plus interest, the day after it's filed, the lien on its face, it's out of date. So typically we will file a lien that says there's a sum owed, there's interest that gets applied, plus all future unpaid assessments, interest, attorney's fees, and costs. That's the continuing lien language. It's just going to continue to accrue until we foreclose or they pay it off. All right. So moving on to small claims collections. So a significant amount of homeowner association and condo debt is collected in small claims court. Because in Oklahoma, it's got a $10,000 jurisdictional amount. That's a lot in assessments. Most associations aren't going to have huge numbers like that unless they've just let their collections get out of hand. If you have an association that the annual dues is $250, if you wait 5 years, you're nowhere near the jurisdictional amount. Okay. Small claims is designed so that you don't have to hire a lawyer. So don't let anybody tell you that you have to hire a lawyer in order to collect HOA or condo debt. You don't, but like with any system, it's like me working on my car. I could probably get it done depending on what it was. I could get by in a pinch, but if it's engine or transmission work, I'm going to take it to a mechanic because that's how they know what they're doing and they get paid well for it. So it's kind of the same thing with attorneys. You could do this yourself. There are some associations that do, but if something goes south or if there's wonky, facts or issues, it's best to have a lawyer help you with that. All right. Talked a little bit about foreclosures and the starting place with a foreclosure. You got to have a valid lien. It is fundamental, and I find this regularly with associations, with managers, with other lawyers, not asking the right questions before you file a lawsuit against somebody, and that's, is this person in bankruptcy? So I've got another slide on the next slide is dealing with bankruptcy, but bankruptcy is a federal law that regardless of your thoughts on whether people should pay their bills or not, it is a fact. Bankruptcy is one of the last vestiges of mercy given in our legal system. And that vestige of mercy turns into a incredibly punitive hammer for people who violate the bankruptcy code. So what does that mean for community associations and their managers? It means you have to ask the question, is this person in bankruptcy before I file a lien against their property? Is this person in bankruptcy before I send them a demand letter to pay me money? If they're in bankruptcy, you can't do those things. There's something called the automatic stay. The automatic stay is a federal law that says if this person is in bankruptcy, you cannot collect against them. They get a breath of fresh air, or at least get to hit the pause button from their creditors. That includes the association. That includes the association's manager. And it also includes the association's attorney. So we have built into our collection system asking these questions. Is it a valid lien before we file a lawsuit against someone claiming that we're going to foreclose this lien? Is this person in bankruptcy? Meaning we don't want to violate the automatic stay. I've had to stand in front of a federal judge and answer the questions whether or not we violate it. I don't ever want to do that again, right? Federal judges are scary. They're appointed, not elected. So we want to ask these questions and make sure we get them right on the front end, okay? But once we clear that, once we get past all the scary stuff, it is, like I said, entirely true that the association or condo can file a petition and summons, can seek foreclosure. Now, this is not in small claims court. This would be either in CS, which is civil special, or in district court, which prefix there is CJ. This is a big lawsuit as opposed to a small lawsuit. It's not going to be over anytime soon. You have full motion and discovery practice, meaning depositions, possibly depositions, and you don't have any of that stuff in small claims court. So typically have to weigh the pros and cons. Foreclosure has significantly higher costs. There's title work, there's appraisal fees that have to be done, there's the publication costs, the notices that have to be published by statute. So it is a much more expensive collections process. However, at the end of this process, you know that there is going to be a sheriff's sale if the person doesn't redeem the property. They could file bankruptcy during the pendency of the foreclosure, and that's going to stall things for a little bit. It's not going to stop the foreclosure ultimately. So a lawyer should be able to tell you whether you could complete the foreclosure What they can't tell you is whether you'll see any money. Now, what do we look at on the front end to try to give you some kind of guidance of, okay, you're going to spend several $1,000s on this foreclosure. Is it worth it? We're going to look at the other lien holders. We're going to see who else is going to be chomping at the apple, so to speak, in this foreclosure. We're going to look at market conditions. We're going to look at the property condition and try to form an opinion based on all the circumstances, whether once this property sells, will it likely generate money to pay the association. If a property's reasonable value is $100,000 and there's a $150,000 purchase money mortgage ahead of the association, the likelihood the association is going to get paid is very small, possibly even zero. So there are some instances where the lender has taken the lead and the lender realizes they're not going to get paid their full amount. And rather than going foreclosure, they're trying to work out what's called a short sale. Oftentimes in a short sale situation, either the debtor or the lender will come to the association and ask them to essentially waive their lien. Our position is typically, no, we won't waive the lien. We will take a pro rata reduction just like every other lien holder, but nothing says the association has to take the 100% haircut while everybody else only takes a 30%, right? Although they will ask you to take the 100% haircut, just don't agree with it. One of the questions that I just saw, if you have a judgment, can you turn it over to collection agencies? Most definitely. There are some attorneys that work off contingency fee. We don't. We bill by the hour. We have not necessarily a flat fee, but it works out to pretty much a flat fee on a lot of work. We have found that with contingency and collection agencies, what you're going to do is have them collect the low-hanging fruit, the people who are ready, willing, and able to pay anyway, if you just communicate with them. Pretty much the people that the association itself could collect. What you need is someone who's going to figure out ways to collect those judgments where the debtor says, I'm not going to pay, you can't make me pay, which raises the point. Once you have a judgment under our legal system, no one is going to make the debtor pay that judgment. It's up to the plaintiff, it's up to the association to get that judgment and to collect the judgment. So knowing the tools and the techniques, the methods of collecting the judgment becomes important. By the way, making people angry, making people feel bad about themselves for being in debt, those are two horrible ways to collect judgments. We have lost some clients, potential clients coming to us wanting to do collections saying, well, are you aggressive? And when we ask them to explain what you mean by aggressive, because in our minds, the goal of collections is to collect the money. And the second fold purpose of collections in a condominium and homeowner association setting is to restore this person as your literal neighbor. You don't want them angry at the board. You don't want them alienated from their neighbors. You want them to pay what they promised to pay, and you want to help them figure out a way to do it, which, by the way, let me reiterate, all of our boards should let all of our members know, any of those people on your delinquency list, send them the link to the housing agency's grant application. I put a link on my blog as soon as I found out about it, because what better way to put happy pants on your delinquent members by giving them a means for free to pay their HOA dues. I mean, you talk about bringing value to someone, be the person to do that. You could be the HOA hero, and our boards hopefully are blasting this information out. but anyway, the point I was making was I've had people say, well, are you aggressive? And when I find out, when I ask them a little more about, well, what do you mean by aggressive? Really what they want is a pound of flesh. They want this person to feel it, to appreciate, the grind of the collections process. That's not my job. That's not my personality. And it's my experience over 20 years. That doesn't help collections. It just makes people angry. So figuring out ways to communicate, to facilitate this person's payment and get them back into good standing, those are good collections techniques that boards, managers, and lawyers can do. So I saw a couple of comments come in. I'm going to scroll through here and see if I can answer. So a couple of questions about statute of limitations. And I know this conceptually, sometimes I have to actually draw a line so that I can remember and think properly about statute of limitations. One of them is, so if the debt's 5 years old and the house sells, you could collect. Probably. The way the statute of limitations, whether it's the house selling or the individual coming to you and saying, hey, I'm ready to pay my debt, you can go back 5 years for collections. Another one was someone owes dues for 11 years, builder never collected from them, HOA was turned over 3 years ago, we filed a lien 2 years ago. I understand the facts. I also understand sometimes the distinction that people make. Well, the builder association or the developer association and then our association, and there really is no distinction. The only distinction is who was in control of the association at a given time. The debt is the debt is the debt. The statute of limitations is at most 5 years. So whoever was in control, whatever they did or didn't do, you can only go back 5 years to collect. Okay, this is a great question. I'm going to cover it pretty quickly, but if the lien is filed before bankruptcy, is it viable? And then what if bankruptcy is revoked? So 2 questions here. So this is another reason why good lien practice makes a lot of sense in Oklahoma. So in our district, in our federal district, which is the 10th Circuit, I said district, in our federal circuit, which is the 10th Circuit, association and condo liens are non-dischargeable in bankruptcy. Okay, so if I were to say you and I enter into a contract, you breach the contract, I sue you, I get a money judgment, I file that. That could be discharged in bankruptcy, but the association and condo lien, the HOA and condo liens are non-dischargeable in bankruptcy. So the answer to the first question is yes, it is still viable. Now, that doesn't mean you can run out and foreclose on it. There is a process where you go through to lift the automatic stay. Depending on the type of bankruptcy, the association may get paid incrementally over a plan. So there is a much more involved answer typically to yes or no, but the quick answer is you can usually collect on that lien. Now then, the second is, what if the bankruptcy is revoked? And I'm assuming what you mean is, well, what if the bankruptcy doesn't end up with a discharge? The discharge is the final order in the bankruptcy case that says what debts can and can't be collected. If a bankruptcy is kicked or dismissed, meaning it doesn't get a final discharge, well, then all of those debts, whether they were dischargeable or not, those are all back on. So it is possible that a bankruptcy doesn't complete. And by the way, I'll mention this too. I hear this dealing with bankruptcies and foreclosures. that it's very common for the association to be served with a petition by a lender who is foreclosing on a property because a person in the neighborhood, a member of the association, hasn't paid their assessment. And what I hear people say is, well, just throw it in the trash because you won't collect anything. That person cannot give that legal advice. They have no idea what they're talking about. I've already told you, and I hopefully am going to impress this. No person can tell you whether you're actually going to collect or not. Now, what that person may think they know is, well, in bankruptcy, the debts are discharged, or well, in foreclosure, the mortgage company gets all the money. Well, that might be true in terms of collecting money from property. It is not always true. If, again, we would have to look at the equity, we would have to look at the value of the property. It may be that the association is throwing money in the trash, figuratively speaking, by not jumping into that foreclosure. So don't let anybody just tell you, well, the sheer fact that there's a bankruptcy or the sheer fact that there's a lender foreclosure means the association isn't going to collect anything. That is horrible, horrible legal advice. So don't listen to it. Do we need a question? Do we need to add something to our process to ensure that there is not an automatic stay in bankruptcy when we file liens and lawsuits? Absolutely, most definitely. And you mentioned PACER system. That's how you do it. You are playing with fire. You are playing with the automatic stay and the civil monetary penalties that go along with violating the automatic stay by not checking to see if someone is in bankruptcy prior to filing a lien and filing a lawsuit. Again, I see it all of the time. It is a ticking time bomb. I can't believe people do this, particularly professionals that associations pay. You can't do it. But it's out there. So the answer to your question is a resounding yes. You do need to double check. And now we haven't talked about the Fair Debt Collections Practices Act yet. FDCPA is another federal law that applies to debt collectors. Some will tell you it doesn't apply to managers. I think that's questionable, particularly if the manager puts in their contract, their management contract with the association, that they are collecting the association's debt. Kind of hard to argue that you're not a debt collector, but it is clearly, attorneys are clearly included in debt collectors. That's why on every email, that's why when you call our office, you get that debt Miranda, because the FDCPA carries significant penalties if you violate it. So making sure that your attorney, manager, third-party providers that are collecting your debt, whether it's a debt collection agency or whoever, that they are FDCPA compliant is important as well. All right. Can a HOA mail a postcard to a homeowner that shows the name, address, and balance due? So this kind of anticipates the FDCPA. The association itself is the creditor. They could do that. They would be safe from the FDCPA standpoint, but they are wide open for a defamation claim from that individual. This is kind of along the lines of what we talked about on Tuesday about posting the names of the delinquent owners. Don't use a postcard, use an email directed to the individual to the email address that they have given you, authorize the association to provide them communications, or use an envelope, a sealed envelope, as opposed to even running the risk that you're going to draw a defamation claim. If a manager or an attorney sends a postcard like that, clear violation of FDCPA, no question about it. One of the things of FDCPA is we can't communicate about a debtor's debt or the debtor at all with third parties. and Postcard. I mean, these cases, these FDCPA enforcement cases, get down to whether the envelope that we send our demand letter in identifies that or gives some clue to third parties that we're trying to collect a debt. So if my firm name was World's Best Debt Collection Lawyer and it gives my name and address, that would be an envelope that someone would challenge as violating FDCPA, because whoever I set my envelope to, the postman can look at it, who is a third party, and say, huh, I bet so-and-so is getting a debt collection letter from the world's best debt collection lawyer. So you can't do any of that. Can you allow delinquent members to work for the association, pool, gardening, and such? So the answer is yes. There's risk and possible liability that goes along with that. And so if you're going to do that, which by the way is a creative way to help neighbors get rid of the delinquency, you have to take into consideration a couple of things. One is the liability issue. What if they get hurt doing the work that you've asked them to do? Second, is there a verifiable system so that you know they're doing the work that you want them to and the association's getting the value? Third, are you making that system of work payoff available to everyone? So we have to be careful in an HOA condo setting that we're not playing favorites, that we are not giving opportunities to people that we like and putting the screws to people that we don't like. And usually, if we're working off a written collections resolution, that makes it easier. It certainly makes it easier on the board so that they don't have to exercise any discretion. They don't have to get into the area of arbitrary and capricious enforcement or discrimination, anything like that. They're just following the checklist. And if the association wants to have a process of allowing people work study, so to speak, then they can certainly do that. There's a question about foreclosure. If the association forecloses, does the first mortgage holder have to join the foreclosure? The answer is no. What they're asking about is something called priority. So if most cases, when a person buys a house, they're going to borrow a bank's money, they're going to put a mortgage on their home, and that's going to have first priority. A year goes by, 2 years goes by, they don't pay their HOA dues, then the association's lien will hit, and it's going to be second in line or junior to the lender. The association does not have to foreclose on the first mortgage company. In fact, the first mortgage company could just let it roll on by. It's not going to affect their lien. It will make getting the property purchased at sheriff's sale more difficult, because whoever's going to buy it, they're going to buy that property subject to that first mortgage. Now, may not be an issue depending on market conditions. Could be that you want to foreclose, get the debtor out of there, and because it's a low rate mortgage, you could put a tenant in there and rent it for more than what the mortgage payment is. Or maybe the association wants to pay off the first mortgage and turn around and sell the property and could recoup that way. So the quick answer is no. There's a couple of ways to do that. That's going to be unusual for most associations. That's a lot of time, a lot of attorney time, a lot of association money. It's not that it can't be done, but just the economics may be such that we're not going to do it. Question about what is the time frame for foreclosures after a lien is filed? It's entirely up to the board. Sometimes the covenants will specify when the lien has to be foreclosed. But typically it's going to be anytime before 5 years if there's going to be a foreclosure. There's a question about locating someone, can't figure out where they are. mention about the assessor site. So if there's not a tenant in there, if there's no forwarding address, no information, property's abandoned, where I would go is social media. I would look for possible clues for an employer. I would look at OSCN to see if this individual has been served somewhere else. You could possibly hire a company to do what's called skip trace, see where their utilities. But if someone doesn't want to be found, then they're going to not have utilities in their name. They're going to stay at a hotel or a long-term Airbnb. You know, they could make it difficult to track them down. All right, a lot more questions about collections, but I'm going to keep moving on because we're half out of time, and I want to talk a bit about junky houses and enforcing covenants. If we have time, I'll scroll back through and get back into some of the collections nitty gritty, but let's spend a little bit of time talking about the general enforcement of covenants. So obviously this is a trashy yard picture. This is some louvers in a southwestern state, I can't remember which, that suspiciously look like the first picture that Prince Andrew or William, whoever it was showing in our slide last Tuesday. This is the neighbor with the car lot. This is a very pink house in Houston. By the way, these are real pictures. These aren't photoshopped. These are the nightmares in other neighborhoods. This was a creative planner in Tulsa. This was a doctor's home, got crosswise with his HOA, partly because the association had relied on pretty poor legal advice that they had the right to fine, and it wasn't the right to fine wasn't contained in their covenants. Doctor who owned this home was sharp enough to realize that wasn't great legal advice, and to demonstrate his protest, which I thought demonstrated not only his sharpness in reading covenants, but his creativity as well. He stuck the toilet planter in his front yard. By the way, that case is a good example of if you would just discuss things, and it's possible to resolve disputes with negotiation rather than litigation. Once the association board realized they didn't have the authority to fine, then the problem went away, and so did the toilet planter. And this, those of you who have seen these slides before have seen this. This was my very first covenant enforcement lawsuit. This was a trashy yard, what the defendant called yard art, but it was way overdone. And this is a lawsuit that was filed Oklahoma County. Association brought an action to enforce their covenants for no noxious or offensive activity, general cleanliness, or upkeep, and was granted an injunction for removal of most of those art items, not all of them, but most of them. So here's how judicial enforcement generally goes, right? There needs to be some kind of communication from the board to the owner. You need to give them a fair warning of what you think they're doing wrong. This is before there's any kind of penalty, any kind of threat of legal enforcement, sending the file to the lawyer. Give your neighbor the fair warning that you would want your neighbor to give you if they had an issue with you. All right. phrase it in a way that's encouraging and that is likely to win them over, not make them harden their position. Just like collections, telling people how bad of a person they are rarely wins them over. It's not endearing. So if you think about some of the times in your life where you needed to hear some hard truth, you had done something wrong or you didn't get something right, think about that employer, that boss or friend that came to you and the way they phrased it, and it helped you see either your error or helped you see a pathway through the problem. That's how you want to conceptualize these initial communications. But if that fails, right, you can lead a horse to water. You absolutely cannot make them drink if you've ever had a horse. So sometimes you could do it all right. You could use the right words, but they're going to fall on deaf ears. At that point, you send them a demand letter. The demand gives them clear instruction. Okay, we tried to work this out. Clearly, it didn't work. This is what you have to do. This is the time frame you have to do it. And if you don't do that, this is what's going to happen. Okay. Sometimes clients come and they want to hire a law firm or an attorney to send an angry lawyer letter with threats and language that may scare this person into doing what the board wants them to do. You can find a lawyer to send that letter. I found that if the board wants to threaten litigation but has made no decision to actually take that action, having a lawyer send that letter is asking the lawyer to send a false statement. So if the board is going to threaten litigation, the board needs to be ready to go to litigation. Now, you don't have to have paid for the petition and have it drafted and ready to file it, but what we can't do is be disingenuous and make threats and claims that, one, you're not prepared to take to court, or two, that you could even get in court, right? And most lawyers are going to help clients navigate those kinds of things. There are typically available penalties, and we all kind of chuckle when I read this bullet, that you could take someone's right to vote in the association away from them for not paying their assessments or for being in violation. What kind of remedy is that? It's often not a good remedy, but it's one that if the individual wants to serve on the board, if they're trying to get control of the association, but they haven't paid their dues, then it's a very important one. Can't serve on the board if the bylaws require them to be a member in good standing. So that's it's not a often used remedy, but it's one that should be available. What is used very often is if you have a swimming pool and it has key card access or electronic access, people get real good about paying their dues and being covenant compliant when they want their kids to go to the swimming pool during the summer, all right? Particularly if they're using the swimming pool and lifeguards as babysitters. That usually gets a lot of compliance. So don't forget that that's available. We talked about monetary fines. The thing about monetary penalties is to make sure there's some kind of system of due process. Now, due process is just, we give them notice that they're about to get a fine. It's the warning letter, okay? And then the second is, okay, we're issuing a fine. You have an opportunity to come contest it, but you have to do this, this, and this in order to do it. So what that does is allows me as association counsel to stand in front of a judge and convince the judge that not only the fine itself is reasonable, the dollar amount, but the process leading up to the fine was reasonable as well. It is drilled into lawyers' heads, and judges were lawyers once upon a time, that due process is fundamental to our American legal system. And so what I want to do is stand in front of a judge and show them, okay, all of that due process stuff that we learned that's so fundamental to our legal system, we are mirroring that with our monetary penalties. Okay. So, and we've already talked a bunch about making sure that monetary penalties are in our covenants, that we're not assuming we can file a lien based on monetary penalties, but that we are relying on covenant language that says, not only can you file a lien for regular assessments and special assessments, but also for monetary penalties. Then we talked about collections, but most of the enforcement actions for HOA and condos, so whether it's trashy yard, whether it's you put the wrong roof on, whether it's you didn't get architectural committee approval or board approval and you put a storm shelter in your front yard, you've got an above ground pool and our covenants say only below ground pool, you're using your home for a saloon and a beauty shop, and this is a residential only area, whatever the covenant violation is, usually you're going to be going to court for an injunction, asking the court to make this person do something. That's called a mandatory injunction. Judge, make them stop using their garage for a saloon or a beauty shop. Or two, prohibitory injunction. Judge, we want you to prohibit them from continuing to do this thing that is creating a noxious or offensive or nuisance to the neighborhood. All right, those have to be brought in district court. Cannot get an injunction in small claims court. We also use declaratory actions pretty frequently with injunction actions. So it's called a DEC action for short, declaratory action. And this is based on statute. So Oklahoma statute says if there is a actual controversy, now we can't run to court and just get the judge to give us an opinion, but if there's an actual controversy, so for example, if there's a question whether the covenants require board approval for sheds or if sheds are just allowed in the discretion of the lot owner, and we have an owner who wants a shed, our board believes that you have to get permission, that might be an actual controversy that you could file. You ask the court to issue a ruling based on the covenants as they read, and then the parties abide by it. Now, it might be combined with an injunction, or it might be a standalone as well. Let's see. So there's a question about a house that appears to have a hoarder in it. I will tell you some of the most difficult cases that come into our office are the ones that have a mental health component to it. And this is whether the person is blacking out all of their windows, and we know that there's hoarding or stuff going on inside, coming out onto the common areas, particularly in condominiums, which is really close living, and all of the exterior is owned by the association. We've had cases where an individual was power washing their home and the inside of their vehicle. I mean, clearly something is not right. But if there's not a covenant violation, so for example, a person blocking out all their windows and filling the inside of their home with junk, that's rarely going to be a covenant violation. Clearly something's going on, and that's one of those areas where the association really doesn't have a remedy and really doesn't have an obligation, except that this person is their neighbor. So for example, attorneys are called attorneys and counselors at law. I think association board members, association managers should also be called counselors at community association, because this kind of hones in on that. There's a lot of time that we're not giving necessarily management advice or legal advice, but we're just helping people navigate what it means to be a good neighbor. And so in that case where you have someone who there's an issue going on, you talk about going to the police, going to the fire department, code enforcement, no luck. Other ideas and things that we look at is trying to identify family members, see if we can locate brother, sister, mother, child, see if we can get the family involved. Unfortunately, with mental health, sometimes the family has been involved, and it's the same with alcohol and drug abuse, that the family's just done. They're very well aware, and they're just run ragged and they're done with the individual. So sometimes it takes creativity, sometimes it takes long suffering and patience. And unfortunately, it may be one of those things that there is no answer that's going to be satisfactory. And we just have to take those on case-by-case basis and do the best we can. So there's another question here about examples of what I deem obnoxious or offensive. Boy, that list is long, starting with the guy sitting on a plane next to me, talking on his phone like I'm involved in the conversation. That is obnoxious and offensive to me. But the one that affects the neighborhood, this one usually, and this is related to personal behavior, not things like in the pics. So if we have someone who is being a terrible neighbor, so standing in their yard, flipping people off, screaming at kids, profanity, just being obnoxious, unfortunately, there may not be a legal remedy. There are a lot of offensive, obnoxious things that we just have to deal with. If it's on social media, the best way to deal with it is just turn it off and don't get on there. It's much more difficult if this person is live at the pool or this person is live at the meeting. So we kind of have to pick our remedy, pick our response based on where we are. If we're at the pool and we have really well drafted pool rules and this person is being obnoxious because they're drunk, well, that's a no-brainer. We have a rule that says no intoxicated people at the pool, and that individual gets tossed. If they stand outside the gate, they scream, they yell, if they're creating a public disturbance, then possibly law enforcement can be involved. If we're at a board meeting and we have individuals who from the gallery or from the audience think that they're going to legislate and make comments and ask questions and be disruptive, well, then that's a situation where the remedy is for the chair of the meeting, usually the president. If by the way, there's no problem with assigning the chair of a board meeting to someone who has more experience, who has better experience, or who has absolutely no problem telling people to shut up. Just because you're the president doesn't mean you have to carry that water. I think sometimes we have board presidents who they're just not equipped. I mean, again, using my mechanics analogy, I mean, if you threw me under an engine and said, fix this engine, I am woefully equipped to handle that, all right? That's when I grab a mechanic and I bring someone in, it's like, well, they need this engine fixed, so let's do it. If you have someone on your board that can handle an angry crowd, guess who's chair of that meeting? It's that individual. So anyway, file that away. You don't have to do that if that's not your personality. If you have someone, you don't want to put someone spoiling for a fight in there. That's not what I'm talking about. I'm talking about someone who either by training or personality, they're just not going to get riled up. They're not going to, take things personally, and they know how to handle a room. Well, if it's a board meeting, then you tell that person, you give them a fair warning. Look, this is a board meeting. This isn't a saloon. This isn't an opportunity for you to heckle the comedian on the stage. This is a board meeting. The purpose of this meeting is for us to conduct business. We'll give you a fair warning, but if you do it again, we're going to ask you to leave. And if a person doesn't leave at that point, if you're at the association clubhouse, they're trespassing. If you're in my home and you haven't left, I'm going to escort you to the door. It's going to be tougher if you're in a public forum. Okay, so think about these things. What are we going to do if this happens? And then you try to cut those conversations off, plan or foresee some of those issues so that you don't get surprised by it. Okay. Is there a legal definition for a home ran business? So if I understand the question, I'll answer it this way. Your covenants should answer that question for us, because if they don't, well, then we are interpreting, or we are worse, we're applying a covenant that doesn't exist. So if we have a covenant that says no commercial or business activities, technically, if I bring files home and I'm working in my house and I'm billing hours, I'm running a home run business. The thing is, no one's ever going to sue me for doing that, not until I put a sign in my yard that said Matt's home law office, and my clients start coming there and my legal assistant starts coming, and I have employees and cars, and I have some indicia of a business. That's usually where we will define a home-based business. Is okay, when it gets to the point that we know you're running a business and it's affecting people around you, well, then that's when we're going to call it a business. If someone's sitting in their jammies and day trading and making billions of dollars, well, good for them. No, it's not affecting anybody around them other than making them jealous. All the expensive toys in the driveway. But when someone opens a daycare, well, now the neighborhood knows about it. Now you have an indicia of commercial activity because you have the elements. If you're running a daycare, you got to have a license, right? You have customers coming to and from the business. And when you add the fact of possibly an employee, if you had to have a paid employee coming to the location, well, now we got everything that a business has except the front yard sign. So we usually look at those, look at the facts, and in all of those cases, the association has to decide whether it wants to spend the money to enforce the covenants. And it's not an inexpensive proposition. Something that I wrote down, this was one of the first questions, maybe it was the first question, and the question was about the ARC, the Architectural Review Committee, or the board waiving covenants. And it reminded me of something that I may have mentioned in the past, but I know I don't have on any of these slides, and that's, we make the assumption that the association is the enforcer of the neighborhood and that the association is the only entity that can enforce the covenants. And it's actually the opposite of that. The association is the possible enforcer of the covenants, but the association can only enforce the covenants if the covenants say the association can do so. The lot owners individually can always enforce the covenants because it's them that own property that's subject to those covenants. So what we're looking for is a clause, a paragraph, a section, article, whatever it's called. It's usually towards the end of your covenants, recorded covenants, and it'll say something like any lot owner or the association aggrieved by the violation of these covenants may bring an action at law or in equity, or for charges or sums due, or for damages. I mean, blah, blah, blah. I'm kind of paraphrasing the standard language. But what you're looking for is something that says, can the association enforce these covenants? because just because you have an association doesn't mean your association can enforce the covenant. Now, there's probably, hopefully, if there is a mandatory association and your covenants provide that that association can collect assessments, there's going to be language about collecting assessments. There's going to be language about bringing an action against the individual. There's going to be language about filing the lien. That does not mean your association has the authority to file a lawsuit because I put the wrong colored shingle on my house. Okay, we have to have that language in our covenants. Okay, so if you don't have good language in your covenants dealing with weathered wood shingles, and everybody only wants weathered wood shingles, if you don't have monetary penalties, if your association isn't given the right to enforce the covenants, then we're looking at covenant amendment. All right, we've only got 30 minutes left. I'm going to talk about covenant amendments. I'm going to let you read this for a second. I know this is an old slide. It still makes me laugh. In fact, gearing up for this, I wanted to test my memory and make sure that this was accurate. And so I know where this is in Oklahoma County. And so I went and I pulled the language, and sure enough, it's still there. It's still horrible. So this, and this is a little more fun to do when we're live because I can hear people laugh and groan and, you know, all of that. But this language is intended to put into place to codify a sportsman's ethic. And that is, you don't shoot birds when they're swimming around on ponds, but it's okay to do it if they're wounded. So the reference to the cripple, it's talking about a wounded animal, a wounded bird. I don't know what's going on about this motor. I don't know what's going on about the boat being in forward motion. I mean, who knows? It's terrible, right? So hopefully you don't have as bad language as that, but if you do, there is a process to amend covenants. All right. So there's two things that you look at in order to kind of gauge what's the likelihood of, or what are we looking at in terms of amendment, right? That's going to be, first you look at the covenants. Do the covenants themselves provide a mechanism for amending? It's usually going to say something along the lines of, these covenants shall run with the land and bind the owners thereof for 20 years, at which time they will automatically renew for 10 years unless amended by the then owners, by a majority of the then owners. Okay, that's a very common covenant amendment clause. What that means is, in those periods of time, the amendment percentage is 100%. So in that first 20 years or whatever the period is, it's 100%. The at which time language, and we actually have a reported case in Oklahoma on this. It was a neighborhood up in Enid. They had a clause similar to that, and it said at which time a certain percentage of owners could amend. Well, the court said, well, what does that language mean other than at that time? So on that day, the percentage of lot owners can vote to amend. But then the next day, we're right back into that restrictive period where it goes to 100. The problem with that language is, for some reason, most developers or their lawyers, and these are usually on older covenants. I don't see this very often anymore, although I think some people still use them. They pick January 1st to be the at which time date. Well, guess what offices are closed on every January 1st? The office that you're going to record this amendment in. And so, you know, this language is terrible. It just creates this dilemma of, okay, well, can we have our vote first, and can we put language in the amendment that says we're going to file it on the 31st and it's going to magically spring to life January 1st when the office goes. I mean, forget all that. What we need is an amendment clause that says we're going to amend it whenever we want, provided we get the right amount, right percentage. Okay. So we have to look at the amendment clause to see what it says. We also have to ask the question, does the amendment clause have a percentage of lot owners, or is it talking about a percentage of the lots? So if the amendment clause says these covenants may be amended by a majority of the lot owners, well, clearly that's talking about the percentage of lot owners. If the amendment clause says these covenants may be amended by the lot owners holding a majority of the lots, well, that percentage is applied against the lots. Okay. If we have 50 lots and the percentage is against the lots, then we have a static number. If it's against the owners, well, then now we have to go through and we have to count the owners. Is there one title holder? Is it owned by a trust? Is it owned by spouses? Do 4 brothers and 7 sisters? We have to cover all of those numbers. So the favored percentage, the favored way to write these amendment clauses is to write a percentage that's applied against a static number, and that's the platted lots. All right. So if we look at the amendment clause in our existing covenants and we think, well, that doesn't make sense, or that's not doable, or I don't like that, well, then we have a state statute that has been in effect for quite some time. That's the third bullet here. It's Title 11, Section 42-106.1. Now, if you go look at this statute, it has 4 subsections, A through D. For regular covenant amendments, we're only talking about subsections A, B, and C. Subsection D to 106.1 deals with the special circumstance where you don't have a mandatory association and you're wanting to create a mandatory association. All right. So just run-of-the-mill covenant amendment, you're looking at subsection A through C. Now, the nuts and bolts for 106.1, the way it works is it deals with time. How long have your covenants been on file? If your covenants have been on file for at least 10 years, then what 106.1 says is you can amend those covenants at any time with a lot owner vote of 70% of the platted lots. So the legislature used the static number, the percentages applied against the lots, the platted lots. If the covenants have been on file for 15 years, then the percentage goes to 60. 60 is an entirely doable percentage. And we do amendment projects across the state, rural counties, urban counties, large additions. I have a very rural neighborhood. They own miles of private street, airport, golf course, all these kinds of amenities, thousands of lots. They have amended their covenants using 106.1. Small neighborhoods of 30 units where it's real easy to go door to door, they've amended using 106.1. So it's very functional. By the way, a couple of things, and this isn't on a slide, some of the things that we look at before I'll do an amendment project, I'm going to ask the board some questions. And I'm kind of like with collections and winning lawsuits, I can't tell you whether you're going to have a successful amendment project. I will tell you, though, if the board or their block captains or whoever isn't willing to go door to door to collect ballots, you're probably going to fail and you're going to waste your time and money on an amendment project. All of the creative ways of avoiding getting a notarized ballot, they don't work. Sending people ballots and telling them, if you don't return this, we're going to count you as yes, doesn't work. Can't do that. I mean, if that worked for real property documents, then every mortgage company would be sending you a mortgage saying, hey, you owe us a mortgage unless you sign this and send it back. I mean, that's just not how real property instruments work. There has to be an affirmative vote. Okay. Now, there are exceptions. There are neighborhoods out there. There are covenant amendment clauses that don't require notarized ballots, right? You might have one of those. But the general rule is if there's going to be a vote counted for a covenant amendment project, whether we're changing one word, whether we're changing all of them, whether we're consolidating 4 sets of covenants into one, whether we're taking out all the declarant language or developer language or Class B control language, whatever it is, the general rule is it requires a notarized ballot. And that notarized ballot must have the title owner's signature on it. So if spouses hold title to property, they both have to sign the ballot in front of a notary. Okay, one can't sign on behalf of the other. That Enid case that I referenced about the at which time, it's a very small, short line, but it's a very important one not to miss in that case as well, where the court says if there's 2 title holders, they both have to sign in order to count it. Okay, so don't miss out on that important piece. One of the things that I look at too is a collections percentage. And this is based on the reasoning that if you have 95%, 90%, if you have a very high percentage of the HOA members who are voluntarily cutting a check year after year, paying the right amount at the right time, that's a pretty good indication that they have buy-in. Whatever it is the board's doing, people are at least okay with it, okay enough that they're going to cut a check. Okay. If the percentage that is in delinquency is 40%, 50%, well, we have to ask the question, what makes us think they're going to sign a notarized ballot? What kind of faith do these folks have in their board where they're not cutting the check? So maybe in those kinds of projects, what we'll do is some community building exercises. We will call in some, when I say we, I mean the board, we don't do this. The board plans some community building things, calling in food trucks, doing trunk or treats, some kind of door prize at the annual meeting, something to generate excitement, buy-in, something. We look for those kinds of factors to indicate that the associations, or excuse me, that the lot owners vote would be successful. One of the other things that you need to think about too is infrastructure. And when I say infrastructure, what I'm talking about is how solid is the association's volunteer base? Do you have block captains? Do you have the neighborhood covered? Do you have people who are willing to go door to door once or twice during the amendment process? Second, how well do you communicate with your members? Do you have an email distribution list? Is your Nextdoor or Facebook accounts so toxic that no one would go on there for any kind of information? The only reason people go there is to scream at each other. Well, that's not going to be a good avenue to get the word out. The message is going to be lost. If your Nextdoor and Facebook is a Garden of Eden, if it is nothing but goodness being poured into your membership, man, that is a good indication that we have a neighborhood who is ready to communicate about tough issues or possibly contentious issues. And we have a means to communicate that the project is coming. All right, couple of, okay, this is a good question. And this is the reason why once we clear the first, okay, it seems like you're in a good position to have a covenant amendment. The very next step that I do is I prepare an amendment memo. I don't know how other lawyers do it. but I have found that preparing an amendment memo is it's not just a logical next step. Oftentimes, it's a necessary next step for the board to make an informed decision. Do they want to go ahead and pay the money to draft the amendment and move forward with this project? So the amendment memo answers some of the stuff that we've talked about. What percentage are we looking at? It also answers this question here about if we have multiple sections and each has its own covenants, do you count the votes from those lots in each section to amend that section's covenants, or do you count them all as a neighborhood? It answers that question, and I provide a table that breaks that down. The answer is if you have Plat 1, Plat 2, Plat 3, and each of those plats have separate covenants filed against them, and you're amending using 106.1, each of those plats have to get the percentage for those, for whatever that plat is. So for example, it's possible that Plat 1 and Plat 2, those covenants have been on file for 20 years. And Plat 3, those covenants have only been on file for 10 years. Well, we have different percentages under 106.1. That's important information to know, right? You don't want to go after a project and, well, Plat 1 has been on file for 20 years, so we're going to apply a 60%, and then find out when somebody challenges the amendment, when you're trying to enforce it in Section 3, we have a procedural problem here. We want to know all of those ins and outs. We want to foresee that going in. Now, it's possible that we have 3 separate plats, that we have a declaration filed for Section 1, and then we have what are called supplemental declarations for Sections 2 and 3. We may be able to use the time frame from Section 1. We still have to count the lots on a section by section basis, but it's very important to ask all of those questions to know how to do this project and not just run into it and, oh, we're going to use this percentage and we're going to get people to sign a piece of paper, or we're going to have them email us, and then the president of the association is going to certify the vote. I mean, I've been involved in cases where I've been hired by a defendant where an association is trying to enforce covenants that clearly aren't valid. And the association ends up losing that case or settling it very quickly once the light bulb comes on, where they realize, whoops, we can't enforce this. We don't want to be in that situation. We want to make sure that our client understands this is how you do amendments, this is how you do them right. Where really the only question is, are we going to get sufficient votes? Okay. The follow-up was, can we amend the covenants to combine them into a single document? Absolutely. We call that a consolidation project. Usually have 2 kinds of amendment projects. You have what I call spot amendments, SPOT. Those are usually 1 or 2 pages. We're only tinkering with a couple of elements. Say you want backyard chickens and your covenants prohibit them, then Article 8 is hereby deleted its entirety and not replaced. We just nuke that clause. That's called a spot amendment. Consolidation projects, update projects, we may come in and wholesale change a bunch of language, or we may take a bunch of documents and squash them together. Those are covenant amendment projects as well, but certainly doable. There's a question here that says, if you're not filed with the Secretary of State, is the HOA valid? Again, like last Tuesday, we talked about, if there's nothing filed at the Secretary of State, the association could be valid. It just could be a valid unincorporated association, which is no way to do business. So we want to file articles of incorporation with the Secretary of State. We want our association to be incorporated and not incorporated. What is the time limit for collecting notarized ballots? So this is a question that I usually get the day the ballots are due. And the question is, well, can we have a couple more days? Can we string this out? Well, think about if a political candidate got to the night of election and they've counted the ballots and they don't have the ballots and they're like, well, wait a second, let's extend this out because I know my people are going to show up and vote for me. We would not accept that. That is unacceptable. That's not a valid, a full and fair voting process. So we can't do that. If we want 60 days in our voting process, well, then let's take 60 days. That's the notice that we give on the front end. But what we have to have is a drop dead date when the ballots are due. If we want it 90 days, then make it 90 days. We usually structure it over 30 days. The whole information meeting, which is a meeting that I usually go to in order to answer questions. I mean, part of the reason you're paying professional fees is so that the board doesn't have to stand there and answer all of these questions. I do it, and then allow board members or block captains to go door to door collecting notarized ballots, and then having the voting meeting, which is really no meeting at all. It's just a drop dead date. So once we've given that notice, if it looks like you're not going to get your vote, well, then you can restart the process. But what you can't do is just decide, hey, we're going to extend this. All right. Question is, if the covenants are on file for 40 years, you get even more. And that's not what 106.1 says. The lowest it goes is 60%. And you get that after 15 years. Question, can you use the 106.1 instead of your CCRs? The answer is yes. So if your covenants provide, and in fact, if you read 106.1, it covers the instance when covenants are filed and don't have any amendment clause. So forever, your covenants are 100%. Well, we're never going to use that. We're going to use 106.1 once we get to the time frame. Question about the board's discretion in enforcing covenants liability. I will pivot back to that. We have just a couple of more minutes left. So this is something that comes up, and usually you hear it from a lot owner whose neighbor is driving them crazy, or they have very particular ideas on how the board should enforce the covenants. And I think it stems too from what we talked about a moment ago, that people think the association is the enforcer of the covenants. So the way it goes is this: individual says, my neighbor is violating the covenants. What's the association going to do about it? The board can look at it and say, well, we agree with you that they're violating the covenants, but we're not going to do anything about it, because the lawyer said the next step would be the demand letter and then a lawsuit. And they told us it's going to cost at least $15,000 for an average covenant enforcement suit. And the board has decided we're going to spend our money on flowers as opposed to lawyers. Okay, that's when the lot owner, the aggrieved lot owner, might say, and I hear them say, board, either do this or I'm going to sue you. All right. Well, this kind of communication definitely comes out of frustration, but it also comes out of ignorance, because the board is tasked with deciding how to spend the association's money. This is discretion. So there's something called the business judgment rule. So if the board, in good faith, based on reasonable advice, in other words, advice that, I don't know, to a layperson, it sounds good, sounds like it's right. They're the lawyer, we're going to rely on them, or they're the accountant, or they're the engineer, we're relying on professionals. Well, then the individual board members are not going to be liable for someone who takes exception or wants to second guess the exercise of their discretion. This is like someone in the back seat claiming a right to grab the steering wheel and turn the car. All they get to do from the back seat is make suggestions. Okay. If I'm in the driver's seat, I control the wheel. Now the radio might be up to the passenger, that might be up for grabs. But the direction of the car, the steering wheel, that's in the driver's control. Same thing with the board. They control the budget. So again, usually what we do when a board comes to me and says, hey, we have this lot owner threatening to sue us individually if we don't do this. Usually what we'll do, kind of slip into the counseling role and, okay, this is how we talk to that person. We direct them to the association, or excuse me, to the covenants and to the language that gives that lot owner the ability to file a lawsuit or to address their neighbor, or maybe forget enforcing the covenants. Maybe we need to help this person figure out how to have difficult conversations and discuss tough things with their neighbor. Oftentimes, what the person is complaining about or what they want the association to enforce isn't the association's job at all. So for example, the barking dog. If there's a dog that is in your neighbor's yard that's driving you crazy, that is not the association's job to take care of that. In fact, it's questionable whether the board could even do anything about that. I mean, maybe the association could bring a noxious or offensive activity case, but the person, the one individual in the neighborhood who's aggrieved, that's their water to carry. It's not the association. So the liability there should be zero. Now, we all know there's a lawyer out there that will take that individual's money, will file a lawsuit against the association and the individual board members. That can't happen. There's nothing we can do to prevent someone from filing a silly lawsuit against us. All we can do is not waste precious time worrying about it, and give it the appropriate attention that it needs, kind of like a tick. I live on cattle ranches. I don't sit around and think about ticks. But when I see one, I give it appropriate response. I kill it, and then I move on to whatever else I was doing, right? It's the kind of the same thing with these lawsuits where I'm going to sue you, individual board member, if you don't do this, right? If that pops up, talk to your lawyer, talk to other board members, give it the appropriate attention, but don't let it ruin your evening. Don't let it ruin your family time. We'll be able to handle it and take care of it. All right.
Matthew, it's 8 o'clock. It's time for us to wrap up. So do you have one last thing you want to say?
Yes, two things.
Okay, go for it.
I didn't get to these slides, but this is very important, and it's a good thing to remember as we end talking about board member liability. I want everyone to make sure, well, three things. I'm going to reiterate. If your association's not incorporated, you've got to incorporate it, okay? 2, the association needs to take a look, the board needs to take a look at placing the appropriate insurance that either is required by your covenants or bylaws or makes sense for y'all's situation, okay? And then 3rd, the association needs to file a form 1120H, right? I don't have this on a slide. It's an 1120H. It's a federal form. It's an annual tax election that the association is going to file. It's not a form you're going to file because the IRS is going to come after you because you owe taxes. It's because under Oklahoma law, your association and your individual board members get really good immunities for filing that. So it helps protect against those silly lawsuits that sometimes get filed against individual board members. The insurance helps us pay for the lawyer to defend us in those. That's why those two things are very important. All right, we're out of time. I know that there was questions that came in that we didn't get to. Georgie, we're doing this again, what, this summer? I think? Okay. So
we don't have an exact date yet, or you and Ashley may have already planned a date, but if you guys haven't already gone to our website and signed up for our emails, please do, and that way you'll be notified when Matthew is back up again. I know you all want to go with me and thank Matthew again for giving of his time to give us this wonderful information, to keep all of you on the straight and narrow, and to answer lots of your questions that you already had. So thank you, Matthew, for giving us wonderful direction in keeping our associations legal and above board, and us as officers in those associations knowing what to do. It makes us all feel like much better leaders. So thank you for that.
My
Thank you.
pleasure. Yep.
Thank you all for volunteering your time as well. I want to make an announcement that one of our next workshops is coming up with the Oklahoma City Police Department on March the 3rd. It's Community Policing Defined. So you'll get to meet Chief Gorley. You'll get to meet Major Scala, who's from the Hefner Division, and Sergeant Scala. Sorry, I promoted him right there. He should be promoted, but they will talk all about community policing, what it means, how it affects Oklahoma City. There is a light supper provided, so come have dinner with some of your neighbors, some of your other people that are out there leading their neighborhoods as well, and hear our police chief talk about community policing. You'll find out how to register for that on our website. Bring the people from your neighborhood, come and enjoy a good evening, learn a little bit about police departments. Give us a call when you need us at Neighborhood Alliance. We're there to answer your questions and to help your neighborhood be the best that it can possibly be. Have a great evening, and thank you all very, very much. Drive safely into the front room, okay? Bye-bye. It's nice that we got thank yous tonight.
Mhm. I'm connecting to our drive so that we can save the chats, so
Oh,
we can
good.
pull the emails.
I was wondering how
Addresses
you were
from
going to do
them.
that.
Yeah.
Is everybody off?
We're getting close. Looks like we just have a couple, 3 more, looks like.
I made potato soup in the crock pot and it smells so good. I can't stand it.
Ooh, that sounds really good.
It's got ham and corn in it. And
Okay,
Well,
I'm
I
coming
removed the
over
last 3
tomorrow,
people.
Georgie, and getting a bowl. Thank you for doing that. Someone was, I think he was kind of lingering because I think he was hoping I would respond to his direct message. I'll just put it that way. And I was not going to respond.
was it an inappropriate one?
No, it's just like, silly stuff, just saying that I was attractive. So I'm just not going
Oh,
to.
that is inappropriate.
It is
Sarah.
inappropriate, but you know what?
Yes.
Yes. Okay. Yes. Yes, it was inappropriate.
Yes, it was.
Mhm.
Can you tell me who it was?
Sharik. Last name, I don't know. I'm still trying to get the Sharik. It won't come up for some reason. Yeah.
That is inappropriate.
What was the name again?
Sharik Rick Books. It's Buksh. I don't know how to pronounce that.
I'm sure if he wanted the slides, it will be on the chat that he sent his email.
Yeah.
Good, because I want his email address, because I'm going to write him and let him know that that's inappropriate. We'd like for him to continue to come to our workshops, but not if he's going to be inappropriate with our staff.
Okay. I will look for that. I'll look for his email address.
Okay, please. Thank you.
And something else we can do, I hope you all can hear me. We're in the middle of dinner time finishing.
Yes.
But
Are you sitting at the little table?
no, we are moved to the big table. We moved to the big table for the last, what, 2 months, I think? Yeah, 2 months. And then she donated or say she didn't want her high chair either. So she took her dad's chair right there.
Oh, hello, sweetheart. Are you having dinner? Hi.
This is my spot. That's that spot.
That's that spot. Okay, that's your new spot. Okay.
Okay.
We can select also on the chat for people not to be able to reach us directly, which is, I've seen it done in sometimes that you can only use message everyone. There's a pros and cons to that, but there's a way to manage who can message who.
Yeah. Hi. I see your wand. That's fun. Thank you. I'm glad you have it.
Oh,
Still lights up. That's
Yeah,
amazing.
it still lights up. She made a bracelet today too that says her name. So
Oh, very good.
yeah. So yeah, that's inappropriate. And then Sarah saved the chat so we can look at the questions
Okay.
that people had.
I'm trying. It's kind of weird. I'm
Oh, I
trying
saved
to.
it just now.
It did? You did?
I did. And I'm pretty
Thank
sure
you, because
I
it was
saved-
not working for me. It just wanted to do. It was not working
Oh, it's
for
still
me.
recording? Do you
Is that what it is going on? It's